Now I am going to dictate a legal passage based on civil case judgment at the rate of 120 words per minute. Let's start. This appeal arises from the judgment decree dated 10th April 2024 passed by the learned civil judge within bracket senior division Alipur entitled suit number 87 of 2021, whereby the plaintiff Srimati Meera Sen was granted a degree of partition and permanent injunction against the defendants, her brothers Amit Sen and Sumit Sen Pera. The facts briefly stated are that the suit property consists of ancestral land measuring 2 bighas situated at Baliganj, Kolkata, along with a 2-storied residential building constructed thereon. The property originally belonged to late Haripada Sen, father of the parties, who died intestate in 2018. The plaintiff, being one of the legal heirs, claimed 1/3 share in the property. She alleged that the defendants attempted to sell portions of the property without her consent and obstructed her access to the house bearer. The defendants contested the suit, contending that the plaintiff had relinquished her share orally in favor of her brothers and had accepted monetary consideration. They further argued that the plaintiff had been residing separately for many years and had no interest in the ancestral home bearer. The learned civil judge, upon appreciation of evidence, decreed the suit in favor of the plaintiff, holding that oral relinquishment without registered deed was invalid under law. The court directed partition of the property by metes and bounds and restrained the defendants from alienating any portion without the plaintiff's consent. Aggrieved thereby, the defendants preferred the present appeal before this court. The learned counsel for the appellants argued that the trial court erred in ignoring the oral relinquishment and the long separation of the plaintiff. It was contended that the equity demanded recognition of the defendant's exclusive possession. The counsel further argued that partition would cause hardship and diminish the value of the property. The learned counsel for the respondent, on the other hand, submitted that the plaintiff's right as a co-sharer was absolute and could not be extinguished except by registered instrument. It was argued that possession by one co-sharer does not amount to ouster of another, and that the plaintiff was entitled to partition as a matter of right. Upon hearing the parties and pursuing the records, this court is of the view that the decree of the trial court warrants affirmation. It is well settled that under Section 17 of the Registration Act, relinquishment of immovable property must be effected by registered deed. Oral relinquishment is legally invalid. The defendant's plea of oral relinquishment is therefore untenable. As regards the plea of long separation, this court reiterates that mere residence elsewhere does not extinguish ownership rights. A co-sharer remains entitled to her share irrespective of residence. Exclusive possession by one co-sharer does not amount to adverse possession unless accompanied by hostile assertion of title, which is absent here. The contention that partition would cause hardship is equally untenable. Partition is a statutory right under Section 44 of the Transfer of Property Act and cannot be denied on grounds of inconvenience. The law provides for equitable division, and if physical division is impracticable, sale and distribution of proceeds may be recorded. In the present case, the property consists of land and building capable of division. The trial court has rightly directed partition by metes and bounds. This court further notes that the defendants attempted to alienate portions of the property without the plaintiff's consent. Such conduct amounts to infringement of the plaintiff's rights and justifies grant of injunction. Accordingly, this court issues the following directions. Number 1, the decree of partition passed by the trial court is affirmed. Number 2, the property shall be divided into 3 equal shares, one for each sibling. Stop. Thank you.